with the accompanying affidavits. And my Lord, what the petitioner's counsel is doing is the father of the house leaving the dining table and going into the kitchen. And is complaining that you have put the salt before the onions. My Lord, within the 10 days that the respondent has under Rule 8.1, he's expected to gather his evidence in those 10 days. So if you have a number of allegations against several people, whatever day you get them in the 10 days is fine. What the law requires that when you're filing, all these must accompany. Now, there is no evidence on record, my Lord, that any of the affidavits that is complaining about was filed in court before the respondent's answer. What we have on record, my Lord, is that the answer, together with all the evidence and affidavits, were filed on the 24th. Were filed on the 24th. So, my Lord, before the 24th, when the filing of the respondent's answer was done, there was no answer. Neither court nor the petitioner would be able to tell whether there is an answer. We can only talk about an answer under Rule 8.1 when it is filed. And my Lord, there is no evidence on record or adduced by the petitioner to show that there were any difference in filing dates of this answer. And it cannot become an answer when it is still in the lawyer's chambers. So what counsel is looking at is the kitchen affairs. He peeped into the kitchen. But what we are saying is that under Rule 8.1, you wait for the food at the dining table. And it came to the dining table on the 24th. And my Lord, precisely, there is no issue as far as those affidavits are concerned. And we beg that the court be pleased to overrule the objection. But my Lord, in the alternative, even if we are to say that there was a problem in putting salt before tomatoes or mixing them up, my Lord, one of the authorities that was supplied by the petitioner's counsel under volume 3, my Lord, in the bundle, that is Muhindo. Rema versus Winfred Kiza, my Lord, on page 886. On page 886. My Lord, that's volume 3. My Lord, that case citing the Supreme Court's decision of Colonel Kiza Besige and Yoel 7, that is number 1 of 2001, on page 886 of the bundle. The Supreme Court held that the court should take a liberal view of affidavit selection petitions, considering the tight time schedule under which they have to be compiled, unless the omission is material and going to the root of the substance of the affidavit. My Lord, when a respondent is served with a voluminous petition of over 1,000 pages, with a periphery of allegations against everybody in every corner of the constituency, it is not possible, as counsel would want it to appear, that you collect all these people, they leave all the work they are supposed to do. So on the final day when for you are doing your affidavit is when you should now start getting their evidence. No. And what we have been doing in election petitions, the moment you are served, you get a number of lawyers, and each lawyer handles different people. Respond, respond, respond. What is important is that when you're filing, you must file on the same day. So it's not that whoever prepares evidence, they file it not. And when they are all going, they go in support of the petition. And that's what Muhindo and the Supreme Court is saying, that we should not be very strict on those issues. My Lord, on the other objection, which was addressing the issue of annexure, on the issue of annexure, my Lord Counsel took at length to impeach this particular annexure. And we, on observation of the same, note that this annexure was intending to support evidence on the total number of registered voters in the 14 polling stations vis-a-vis the total number of registered voters in the constituency. And this is a document, as alluded to by the first respondent, had been obtained from the Electoral Commission. However, with the hindsight that the same evidence has been adduced by the petitioner in the tally sheet and in the attached voters' rolls for the 14 polling stations, my Lord, we would concede to this on that annexure. My Lord, is one, which is the parking list, but its complex, it has not been marked. Annexure A to the affidavit of the first respondent in answer, in support of the answer to the petition. So we can concede to that because that evidence is already on record. But it can be done away with as prayed. My Lord, the third and last appeal that was raised was in respect to the affidavit of Nalukoola Rita. My Lord, it was the submission of counsel for the petitioner that Nalukoola Rita's affidavit did not comply with the requirements under the Commissioner for Oath Act. But it's our submission briefly in response, my Lord, that counsel for the petitioner's submission is unsustainable because he does not lay a sufficient background. He doesn't lay a sufficient background upon which such a prayer can be made. My Lord, when you look at the affidavit of Nalukoola, it fully complies with the requirements of the Oath Act. It was duly commissioned by an authorized officer. My Lord, under cross-examination, the witness before court told the court that she appeared before the Commissioner for Oath. She also told the court that they explained to her the contents of her affidavit, She also told the court that after explaining, she got her copy and read it. She also gave evidence that she swore. And the only question which the counsel for the petitioner put before her is whether there was a book. In cross-examination, whether there was a book, was there a book? And it remained vague as that. My Lord, when you go to section 5 of the Oath Act, the requirement, the main requirement, and this has been demonstrated in a number of authorities, is that the deponent must physically appear before the commissioner. And the deponent must understand the nature of oath she's taking and what she's swearing onto. My Lord, all the cases, including John Baptist Kapoza, that were supplied to this honorable court by counsel for the petitioner, in all those authorities, my Lord, the deponents did not appear before the commissioner for oath. Did not appear before the commissioner for oath. And my Lord, that is conduct that the Supreme Court was condemning. That is conduct that the Supreme Court was condemning. And my Lord, that is distinguishable. And that is distinguishable on how the oath is taken, the mode of taking the oath is a detail. Under section 5.2 of the Oath Act, it can be by Bible, it can be by Quran, or any other custom or mode acceptable. Because we have people who don't even, they are Christians, but for them when they are swearing, they don't touch the Bible. And that is them. Others will only put their hands up. So it's not about a book. Even a book does not mean a Bible. A book can be a book as a book. And that's the only question which counsel asks. So it is very insufficient to lay a background for a PO, as counsel would want court to believe. And finally, counsel made an alternative prayer. Counsel made an alternative prayer that if court is to agree, with him and strike out the affidavits, of Nalukoola, then even her testimony on oath in court should be expunged, should not stand. My Lord, I would associate with the same if I was the petitioner also. Unfortunately, that's not what the law says. And that's not what courts have held. So one, for the record, we do not agree that there was any non-compliance with the oath of the Commissioner for Oath Act. But even if there was, which isn't true, the Court of Court of Appeal, my lord, in the case of Mugema Peter versus Mudiogola Ben Nasa, we shall rely on this authority later on other issues. My lord, that is Election Petition Appeal number 30 of 2011. My lord, in that authority where I happen to be a party, this time not as a lawyer, but as a witness. How do you deal with vivavo evidence? The evidence that the witness gives here. In the event that the affidavit is expunged, which cannot be done in the current circumstances for the reasons I've given, you also ignore the evidence that a witness gives under oath, and that this oath the same does the first oath that was taken before the commissioner affect this oath when the witness comes to court. My lord, in that decision before you, I also encourage my brother to read there. My lord, page 17. Under paragraph 10, my lord, the court talks about how evidence should be given here under section 58 of the Evidence Act. In this election petition, when the witness comes here and takes oath, they are treated the same way we treat them in civil proceedings. That's why the moment she comes here and takes oath, they are cross-examined on what they saw, what they did, what. My lord, on 17. Yes. Section 58 of the Evidence Act. Yes, my lord, I'm flowing there because on the following page where I'm going to take you, court comes back. So I wanted to just highlight the background. My lord, when you go to page 18, my lord, in this case, where I happen to be party, the evidence of one of the witnesses, the respondent's witnesses, was struck out because it hadn't complied with the Commissioner for Oath Act. Through cross-examination, it was discovered that the witness did not appear before the commissioner, and it was the witness's evidence himself, Reverend Indanda, that he hadn't appeared before the commissioner. And what did the court say? I conclude, I've highlighted that part, my lord, on page 18. On the basis of section 58 of the Evidence Act, and on appreciating the above legal authorities on the point, that evidence given to court on oath vivavo, like what Nalukoola did here in court after taking oath, under the supervision and the superintendence of a presiding judge, is proper and valid evidence that the court must consider. And my lord, that one closes our response to that criminal objection, that both limbs of the objection in respect to Nalookola's affidavit cannot be legally sustained. And the petitioner's counsel did not lay a sufficient background for raising the same. Most of life. My lord, I'll take leave on that and will request our colleague handling issue one.
Issue number 1, my lord. The affidavits of, it was turned down to the affidavit of then For the record, my name is Eunice Nalukoola. My lord, I'm submitting in respect to issue number 1, whether the affidavits of Chamber Nathan, Mawumbe George William, and Ben Mukasa in support of the first respondent's answer to the petition are legally admissible. Which issue, my Lord, has since been whether the affidavit originally was whether the affidavit of Chamber Nathan, Maumbe George William, much of that is my Lord. Whether the affidavit of Ben Mukasa in support of the first respondent's answer to the petition is legally admissible. My Lord, counsel for the petition has submitted that the affidavit of Ben Mukasa should be struck off because he procured witnesses, George William Maumbe and Chamber Nathan. He says that the affidavit that the witness participated in an illegality and should not be allowed to continue participating in the proceedings, my Lord. But my Lord, there's nothing illegal about the affidavit of Ben Mukasa. It fully complies with the Commissioner for Oaths Act. It complies with the Oaths Act, and it was deemed read by court. My Lord, also the counsel for the petitioner had an opportunity to cross-examine Ben Mukasa, and he conveniently disregarded that opportunity. He did not even make a prayer to cross-examine him among the people that he wanted to cross-examine. But now he wants to turn around and make presumptions and allegations and submissions from the bar about supposed illegality. My Lord, even when you peruse the affidavit of Ben Mukasa, it is only in paragraphs 10 and 11 where he makes reference to one of the expunged affidavits of George William Maumbe. But even as he's making a reference to that affidavit, he only says that he had an opportunity of perusing, of looking at that affidavit. And that is all he speaks about concerning the expunged affidavit in support of the first respondent's answer. He makes no mention whatsoever of the affidavit of Chamber Nathan. But most importantly, my Lord, which is a well-known fact by now in these proceedings, these two affidavits have since been expunged. So it is our submission, my Lord, that we cannot have a conversation about procuring witnesses, about the action being an illegality when the purported procured witnesses no longer have any evidence on the record. My Lord, what counsel is trying to do is to sort of raise the dead. And I think it's important that he lets the souls of the departed affidavits to rest. My Lord, counsel's submission about an illegality, the decision he has furnished to the court, all that is evidence from the bar. There's totally no illegality. Totally. And to expunge Ben Mukas's affidavit in support of the first respondent's answer, my Lord, is to deny both the first respondent and even Ben Mukasa a right to be heard. It's against the tenets of a fair hearing, my Lord. The affidavit Ben Mukasa was accused of several acts of bribery by first the petitioner. These are fortified in the affidavits by the affidavits of Wanjara Solomon, Maumbe George William, Chemba Nathan, and all of them are accusing him of committing different acts of bribery. He should be allowed to defend himself. He should be allowed to respond, my lord, which he has done and filed an affidavit, which is already being read by court. My lord, our prayer is that if it pleases court, only the two paragraphs 10 and 11, only three paragraphs, my lord, 10, 11, and 12, the affidavit of Ben Mukasa be severed from his affidavit. My lord, severing portions of paragraphs from an affidavit is not removable. In the case of Kiza Message versus YKM, the presidential election petition of 2001, cited with approval in Mutembuli Yusuf versus Nagumu Moses Musamba, at page 16, my lord, an extract from the judgment, the holding of Justice Mulenga, observed that in my view, a court can reject offending parts of an affidavit while accepting the rest of the same as it rejects inadmissible oral evidence. My lord, we pray that only paragraphs 10, 11, and 12 be severed in the affidavit of Ben Mukasa, and the rest of the affidavit be useful for this court in evaluation of evidence, my lord.
In relation to the factual aspect that will be back and bring it back in the buttress them with the law, the case to the police. May I do